afternoon, ladies and gentlemen. Welcome to BW Legal World's Saturday Solution segment, where we speak with experts on hot legal topics and latest legal developments. And today, we are talking about revolutionary tech innovations like the Internet of Things, artificial intelligence, automatic cars, 5G communications, blockchain technologies that are advancing at breakneck speeds. Now, how must the current regulatory framework adapt to the evolving needs of IoT, AI, and innovation in technology in the midst of issues like data security, product liability, intellectual property, that together perhaps is rendering our existing regulatory framework obsolete? To make this happen, we're joined by Ms. Savitha Jagadeesan, who is the Senior Resident Partner at Kochhar and Company and heads its Chennai office. Her practice areas include corporate law, labor law, intellectual property law, and TMT law. She is also the honorary legal advisor for the Indo-Australian Chamber of Commerce and co-leads the Legal Affairs Committee for the Madras Chamber of Commerce and Industry. Welcome, Savitha. We have with us Mr. Asim Abbas, partner, LNL Partners. Mr. Abbas specializes in technology, media, and telecommunications. He comes with a rich domain expertise in TMT-related assignments related to policy, regulatory, contractual, compliance, and approvals and litigation. Before turning to law, Mr. Abbas was a civil servant for 9 years in the Department of Telecommunications and also served as Director TMC in the Ministry of Communications. Welcome, Mr. Abbas. We have with us Sanjay Notani, partner, economic laws practice. Sanjay co-heads the International Trade and Customs practice at the firm, and is also appointed to the American Bar Association steering group of the Export Controls and Economic Sanctions Committee representing Asia. Sanjay has in-depth experience in advising various multinational companies on import and export control, as well as licensing issues, specifically the dual use of goods and technologies regulations maintained by various ministries. We also have with us Sushanth, Samudrala, cyber law expert and techno legal consultant. Sushanth is one of the 45 cyber law compliance auditors in India. He has worked on international cyber law and cross-border techno-legal aspects and has served clientele across the globe on technology legal matters and techno-legal agreements, including cloud computing agreements, data protection agreements, IP licensing, IT contracts, website and mobile app agreements. So a very warm welcome to you, Sushanth. Sushanth today is also joining us only on audio because of some other travel engagements that he is on the road. So thank you so much and a very warm welcome to all the experts once again for joining us today. I'm Ashima, Ohri, Managing Editor of BW Legal World, who has the honor of moderating this August session. A very warm welcome to all our audiences as well, joining us across various platforms. So, experts, warm welcome again, and let's dive right into this conversation with opening remarks from all of you. The question is the current regulatory and legal framework of India keeping pace with the advancements in technology when we speak of IoT, AI, and the works? We'll start with Mr. Abbas. Your opening comments, please.
Thank you very much. And I'll start with, let's say, the telecom revolution, which has happened in the past. India has more than 1 billion mobile subscribers and around 800 broadband subscribers. The telecom network has reached rural and remote areas. The reach of the telecom network, the subscriber base, and the digital products and applications are the drivers of this digital revolution. And when we call digital revolution, essentially entails, let's say, fintech, e-commerce, e-governance, IoT, artificial intelligence, OTT, drones, robotics, smart cities, and etc. So the success of fintech or digital payment revolution in India could be possible because of the reach and spread of the telecom network. So while we have all ingredients necessary for the digital push, all we require is a forward-looking, enabling regulatory framework for these technologies to grow and spread. Now, this digital revolution generates a huge amount of data, both personal and non-personal, which requires a robust data protection regime to handle this data explosion. Data today is the most important economic asset, and it needs to be protected and regulated to ensure that it is used and harnessed as per the best practices available in keeping with the principles of confidentiality and privacy. While we have made progress in case of personal data in the form of PDP bill pending before the Parliament, we may have to take some more steps in case of non-personal data, which will be generated in a huge volume by IoT and AI devices. So these are, let's say, my preliminary or the opening comments.
Thank you so much, Mr. Abbas. Moving to Sanjay. Sanjay, your comments, please.
Thank you. First of all, very good afternoon to everybody. Gives me great pleasure to be here, sitting in part of all the legal luminaries, particularly from a technology perspective. Since Mr. Abbas has already touched nuances of technology, I'll play the role of a lawyer, particularly on the perspective to say, throughout much of the past century, it was not very difficult to adapt to new technologies. And there was sufficient time we all got getting used to teleprinters, fax machines, word processors. But things have rapidly changed, in the latter part of that period. How and why the legal must be transformed in response to technology advancements. I think technology has now reached a tipping point where it can be meaningfully applied to our work. Dramatic developments which will force us to rethink entire areas of practice, jobs, economies. And it is very clear that technology is a state where it can bring both challenges and opportunities. And today what we are living is very, very frequent and unpredictable disruption. But of course, technology must not be seen as something to be vanquished because it threatens to disrupt or challenge. And we have to get accustomed to, of course, operate. Technology, of course, holds a key to productivity, effectiveness, and therefore, there is an opportunity for us to leverage, and accordingly important for law to catch up with technology and bring the best to the society as what we want. Thank you.
Thank you, Sanjay. Savitha, over to you, please.
Thank you so much, Ashima. It's a pleasure indeed to share the forum with these amazing gentlemen. I've followed most of their work, and it's truly great to be on the same platform. On my part, I think what I'd like to reflect mainly is, this whole shift that's happening towards a lot of them who essentially want to get into the whole AI race. And there are a lot of statistics that essentially is indicating that, of course, your next gold is data. And most importantly, this data is what essentially runs these artificial intelligence machines. What is very amazing with regard to AI is the fact that the very concept, as it says, it's supposed to equate itself to human intelligence. And therefore, that's where the question arises, that whether or not AI will change the whole gamut of how you look at laws and regulations, whether it is when you use intelligent robots, you basically giving them the freedom to speak, then would there be any constitutional issues that essentially arise? When you're using your AI-driven bots, you're essentially looking at, commercial transactions, whether or not contract law essentially would require to be revisited. Or if you look at, the driverless cars, which is mainly driven with AI technology, if there is an incident that takes place, where does the responsibility lie? There is also a very interesting discussion that's happening, that the existing framework is more than sufficient. You have regulations that are in place. You just need to address this, which is mainly, you give AI a personality or you don't give AI a personality. So these are some of the key issues that are coming up. But more or less right now, when you look at AI, it is what we call narrow AI, which is it's very, very weak in its system. There is only one perspective that is there. So by and large, the discussion has been that the present regulatory forum is more than sufficient to address this. But in the event it gets to be strong AI, then at that point, because of the amount of acute intelligence that would be utilized, and there would be a distinction between human intelligence that is incorporated, there might be a requirement to revisit what exactly is AI. Just one little thing that I would like to also say, like in Nevada, they have a particular statute which essentially does not define AI because they find it very difficult to circumvent or associate it. And that's the reason why they just use it in a very loose term so that it enables their present legal system to address if there are any issues with AI.
Thank you, Savitha. Thank you so much for those inputs. Sushanth, over to you for your opening comments, please.
Hi, everybody. A very good afternoon to all the panelists and the organizers and all the attendees. It's indeed a very interesting and yet a thought-provoking session organized by the organizers today. And I feel more than happy to be part of this wonderful August assembly, because the reason here is that technology is something that already has become a part and parcel of our life. I don't think there's anybody without using technology in this room, or for that matter, anywhere across in the country, right from the uneducated to the topmost people in the country. I think everybody is using technology today. But what becomes very important is that we already started doing a bit of progress on the legal front, because I would say that we have in India a law which is the digital law, because it's something I feel that is one of the most significant laws as far as digital transactions are concerned. That is the Information Technology Act. And we're going to just celebrate the 21st year of it coming into force. So that be so, I think that's just the beginning step that we have done ahead, because it's the only law that governs anything and everything that is digital in nature. Because I don't see that anything which is not covered by this law, because the fundamental agenda of this law is to provide legal recognition to electronic and digital transactions. So whether be it blockchain, whether be it IoT, whether be it AI, whether be it NFT, or be it any kinds of technology or technological innovations, I think broadly everything makes use of electronic and digital environment. And needless to say that everything gets itself covered under this particular legislation. But the fact remains is that these technologies bring in very unique and specific sets of legal challenges and obligations which need to be applied and approached in a distinct manner rather than having one common legislation. Right? Because when you look at blockchain, I think blockchain revolves around so many different areas. And then IoT, it's not just bringing these devices, but I think cyber security is something that will play a very, very critical role when I talk of a legal framework concerning IoT, because cyber security law has already begun, and countries like California have already started to come up with cyber security laws in the country. And the UK, the United States have already come up with distinctive legislations pertaining to IoT. And the state of Illinois also has come up with one small piece of regulation that is governing video interviews, specifically, which is called the AI Video Interviews Act. So I believe and understand that, despite the fact that we have an initial law which provides a kind of legal recognition, but there is much more that we have to do today, because I believe we cannot use the 20th century mind to handle the issues of 21st century. So thanks. I think these are my opening remarks.
Thank you, Sushanth. Thank you so much. And what wonderful inputs from everyone. I'll now, open the floor again to Mr. Abbas. Mr. Abbas, you spoke about telecom, obviously an industry at the center of all this revolution. How is IoT impacting the industry, and what are the gray areas that need attention? If we could have more details from you on that.
Okay. Thanks a lot. Thanks a lot. And I think IoT is a very, very important topic. As for the industry expert, one big thing or a big bang which will happen will be in the IoT sector. Now, before coming to, let's say, at what stage we are as far as the regulatory front and what are the gray areas, the first question is, what is IoT? How IoT is different from the other term which is generally used, M2M communication. Now, M2M communication, as per the definition, is any technology that enables network devices to exchange information. Now, it is an automated information inter-exchange between machines, appliances, or devices using wired or wireless technology. So M2M is a subset of IoT, and IoT is an aggregation of many M2M applications. So M2M connection form part of the IoT, which along with big data analytics, cloud computing, and sensors can run autonomous machines and intelligent systems. So it's essentially a big system in which the machines have sensors and there are embedded SIMs and there is a communication happening amongst these machines. Other important factor of IoT is that it is not related to any sector. It's a sector agnostic. It will have let's say an application in agriculture, the smart city, smart grid, smart water, smart transportation, smart health, smart cars. So its application goes across the sectors, and then the issue of regulation comes. So regulation in IoT cannot be sector specific. It has to be sort of a holistic and integrated approach. Broadly, if one has to define the applications of IoT in one line, it provides connectivity from anyone at any time and place to anything at any time and place. So that essentially is, let's say, the scope of an IoT, and there is a whole ecosystem which is evolving, but still it is a very early stage. And I think the big push of IoT will come after the allotment of 5G spectrum by Department of Telecom. With respect to that spectrum, some permissions have been given for trial, but in terms of allotment and all, it has yet to happen. But that will be a big push of IoT in India. And now, in terms of a regulatory framework, the National Digital Communication Policy of 2018 identifies IoT as an important area, and it specifically states to simplify licensing and regulatory framework and enable IoT by a rollout of 5 technologies. Now, in pursuant to that, there have been a lot of consultations based on the TRAI consultation paper, and then it gave recommendation to DOT. DOT accepted some recommendation on the regulatory framework of IoT, and then issued a draft paper to seek comments from the stakeholders. So let's say the recommended regulatory framework is that there will be 3 players. This I'm talking from a regulatory point of view, but there will be a huge number of other players in the whole ecosystem. And these 3 players are M2M service provider, which will require registration. It provides M2M service to third parties using telecom services. Then you have VPAN or a VLAN connectivity provider, which requires registration. It uses wireless personal area network or a wireless local area network technologies to provide M2M connectivity for commercial purposes in unlicensed spectrum. Now, in case it is used for a captive use, then there is no requirement of registration. And the third category is that the DOT is creating a separate category under the existing unified licensing regime. And so there is an M2M service authorization. So in case a connectivity is provided using LPWAN technologies, then this service authorization is required. So this is the suggested regulatory framework, and most probably in days to come, there will be guidelines where this regulatory framework will be implemented. Now, the next question is, what are the challenges? And these challenges, I'm essentially limiting myself to the regulatory gaps or the gray areas of challenges. The first is the clarity on international roaming. As you know, that IoT essentially runs on SIMs, which are embedded in the machines. And there are machines which are imported from outside also embedded with an international SIM. So the question is that whether these SIM which are embedded in the machine can be used for international roaming purpose on a permanent basis. And so it's a sort of a gray area, some discussions, some recommendations TRAI has given, but it is yet to be clarified. The other issue is KYC and traceability. Just to give you an example, that if there is a card which has an embedded telematics, which has a SIM in it, and I have bought this car, so that SIM will be in my name. But if I sell it to somebody else, then how do I give that information to a telecom operator? Because telecom operator has to ensure KYC. And also in a situation, there is a requirement that the SIM has to be traced as per the license agreement. So how do you ensure this KYC and traceability when the machine in which the SIM is embedded gets transferred and somebody else is the owner? So that system is yet to be put in place. Then there are recommendations that there should be a separate 13-digit numbers to be used for SIM. Then there are policies relating to EMF radiation, because if there are so many SIMs embedded in the machines, then pollution, the environment-related issues, AMI radiation. Other big area where a lot of work has to be done is the standardization and specification of devices, interoperability, testing and certification. TEC, which is the Telecom Engineering Center, has worked in case of automobile sector, and they are working on others, but there's a lot of work which needs to be done in terms of specifying sectors. So with respect to IoT, let's say to conclude, now the IoT ecosystem includes device manufacturers, software application developers, network and connectivity service provider. So it's a sector agnostic area. So the regulatory framework essentially should be holistic in nature and with integrated approach involving lots of departments, or rather involving the departments which are impacted by it. So, but I think, as I said earlier, once the 5G spectrum is auctioned and that spectrum is used for this service, there'll be a big push for IoT service in India.
Thank you, Mr. Abbas. A follow-up question on that. Great points on clarity on roaming and KYC and the 13-digit SIMs and all of those things in place. But what is the spillover effect of some of these things on other legislations? In a yes or no sort of a response, do we need a framework which is dedicated to managing all of these technologies, or will it have a spillover effect in all of the legislations currently in the country will need an overhaul?
So we don't need specific legislation. I think existing legislations and the license terms and conditions would be fine. It will have a spillover effect with the other sectors, but that spillover effects, I think, will be taken care of by the current terms and conditions of the license agreements and all. That is from a legal front. On a non-legal aspect with respect to development of standards and all, I think it will have a spillover on other factors which requires more coordination, collaboration, and consultation across sectors to have a consensus.
Absolutely. Thank you so much, Mr. Abbas. Sushanth, coming to you, you've been at the forefront of all of these technologies, and I'm sure my sixth sense tells me you have a lot of use cases to share with us in that. So could we have some of those practical areas where you've seen technology, mixing with the consumers and the issues that came from it?
Yes, certainly, Ashima. I think I would like to give you very different kinds of cases that have come to us specifically during this COVID-19. And in this era where I think almost all of us are making use of the online meetings, whether it be it for education, be it for profession, be it for conducting professional meetings. I think a very interesting scenario is that, we got this case of a school teacher who was actually conducting an online class in her residence, specifically in her bedroom, where she had an IoT-based device. And she started to take her online classes as usual and never expected that this is going to impact her life altogether. But lo and behold, a week later, she received a parcel from a very, very famous e-commerce portal. And then she was surprised to receive that because she never ordered for the same. And then she was absolutely in a state of shock, and she rang me up, and then we started discussing about the various scenarios. Then we came to understand that the said IoT device in the bedroom of the faculty was actually switched on during an online classes, and the said device overheard the conversation, interpreted it, and went on to order it in the respective platform. I think when we have these IoT devices, one of the biggest problems that I can actually perceive is they are actually peeping into all kinds of transactions and all kinds of conversations, for that matter, whether it's personal, professional, social, or for that matter, any conversations. So I think this is one interesting case because, it can impact any one of us, because today I don't see anybody without these devices, whether it's Amazon Alexas, whether it's Google Minis or Google Nest, whether it's Amazon Echo or anything like that. I think this is a wonderful scenario. And apart from that, we also had quite recently come up with one of the cases wherein a smart TV was actually alleged to be hacked. And as a result, a lot of private pictures of people were captured, and then they were actually available for sale on the darknet. And this was realized when a fake profile got created out of these pictures. So this is another interesting area I thought of sharing, because the IoT penetration today is left, right, and center. So because manufacturers of these televisions have today begun to discard manufacturing normal TVs, but it's only the smart era. I think in this kind of a scenario, it's also cognizant for all of us to be aware not just of these digital technologies, but we also need to be alive to the fact that what are the do's and don'ts when we make use of these technologies. I think that's also a very interesting question, because IoT devices bring in huge amounts of privacy and also a lot of intellectual property, for that matter. See, just take an example that an IoT device transacts and records a lot of conversations. What happens to that intellectual property? And quite recently, way back in 2016, this was the first case when it came to IoT, because we had a company who approached us for a legal consultation when they wanted to actually install IoT sensors in our electricity meters, specifically in the state of Maharashtra. And they wanted to ensure that we, as a consumer, are aware of our actual consumption of electricity. Well, that's a matter that's going to be a different one altogether today, because if the same gets hacked and the same is able to give access to the outsiders, then just look at what kind of damage can happen. We already started to see incidents like the blackouts in Mumbai, and also for the state of Telangana, there was an attack, but fortunately we were able to arrest that particular attack. I think it's very interesting to see these new manifestations, but they are actually a lot of thoughtfulling processes, because the moment you use these. And quite recently, when I talk about AI, we also got one case where we have the state of Illinois come up with a small piece of legislation which gives in certain kinds of obligations upon the companies who are making use of the videos of the particular employees to actually make use of AI for the purpose of evaluating their creditworthiness. So we had a client who in the state of Illinois developed a particular AI-based system wherein they could just play the video of an employee, try to analyze it using AI, and then understand whether the candidate is fit for the job or not. So just like you have your civil score in loans, so they have a credit-worthy score which was given, and as a result, they used to filter out candidates and make recruitment in a more easy manner, an effective manner. But little did they realize that there were legal obligations in that matter. So though AI brings in huge amounts of legal policy regulatory frameworks, I think this is one small piece of legislation in Illinois which has come up with certain obligations, like the consent needs to be taken from the employee. He needs to be aware that AI system is being used for actually trying to understand and analyze his behavior. And there's an option of he requesting the company to auto delete the said video for more than if it is more than 30 days old. And the video should not be used for any other purposes. So these are the 4 golden principles that AI Video Conferencing Act brings on the table. So I think these are very interesting cases when it comes to AI and IoT that we have actually encountered during this period of COVID-19, as also because we constantly work and advise people on the intersection of law and technology. And there are lots of other interesting cases as well. But, when it comes to IoT and AI, I just recall these 2 very interesting cases.
Thank you, Sushanth. This makes me wonder, a question comes to mind. I thought I'll ask you, increasingly so, everyone's now chatting on these chat boxes, legal AI chat boxes, when we have any interaction with our e-commerce platforms or any of these other websites. Now, what happens if a chat box tells you to do certain things? Is there a recognition of that sort of a contract, that, your compensation is to be given for something you return, or we refund this or something? Host of suggestions come across when you're chatting with the chat box. Now, in that, what happens and what sort of a relationship is a consumer having with the chat box? What are the legalities and the issues there?
I think it's a very, very fascinating question, Ashima, because at the outset, I think, a lot of us today are making use of chatbots when we specifically talk about consumer-related experiences. Whether let's take Swiggy, let's take Ola, let's take, any other thing like Samsung, LG or something like that. I think all of them are now making use of chatbot. And these chatbots are trained to ask you a specific set of questions. And then based on the input that they gather from you, they actually try to increase the conversation. But nevertheless, there's still going to be a lot of legal ramification in that, because by and large, if the said chatbot turns to be rogue, or it turns to ask you for some personal and sensitive information, then I believe that the company who's actually making use of the said chatbot will have to also exercise due diligence, and they need to specifically have a policy in place and take your consent for the same. And what becomes very interesting is many times that companies are providing chatbots as a service to other companies. So in this scenario, the companies who's offering this chatbot as a service also would be legally held responsible, and they will have to demonstrate that there was nothing from their end. If so, if there is something beyond their control and they're in compliance with the laws, I think they're immune from legal liability. But what becomes important is, end of the day, all these are nothing but data and data-driven devices, and a lot of responsibilities would have to be straddled upon these coders who actually code these, and also companies need to wake up to the fact that the moment they're making use of the said chatbot, they're integrating the same with their website or mobile application. It becomes equally important that they also have in place adequate, reasonable security practices and procedures as per the law, so that their exposure to law and legal liability is bare minimum. But nevertheless, I think as a consumer, as a user, I will also be alive to the fact that if there is a specific policy, I will also understand the kind of relationship, because this is very important. We had one of the speakers just mention about the legal status being given to AI. I think this is also one interesting question. How will you actually try to accord legal status to a chatbot? So I went on to write a book called Chatbots and Law, which is available on Amazon, where I tried to dwell in the different kinds of legalities and the legal challenges that chatbots bring across, not just to the business entities, but also to the users and also to the developers of the said chatbots. We only had at that point of time one law, which is specific to only California, where California had come up with a new bot law, which only was very specific. But I think there's a lot more to come in the future, because it's today. If you were to ask me about legalities of chatbots, and I were to author that book, and if the book were to be of 100 pages, I think we're only in the 5th or 6th page. The 90 odd pages which need to still be in the table. So these are just examples.
Absolutely, Sushanth. So thank you so much, Sushanth, for those wonderful examples, and also takes me to Savitha now. Savitha, you mentioned legal personality and personhood to AI. Now, a similar example, taking forward the conversation from our previous panelist, if I am in a sort of a row or a dispute with a chatbot and I go to a consumer forum, now, what am I looking at? We'll be looking at, what sort of laws and regulations or rights and issues are we looking at?
Yeah, Ashima, so like Sushanth indicated, the thing with, whether you're looking at the extensions of these machines, at the moment, what is happening is they're saying that you cannot create a distinction between the machine by itself and the creator. So whatever is the responsibility as far as that machine is concerned, it will be attributed to that user. So when we look at the chatbots also, the chatbots have been fed certain data which enables them to give those responses. And that data essentially is coming from the owner of that particular chatbot. So even if there are two things now. There is the creator and there is the person who's the company who owns that particular chatbot. Now the creator is the first step, but the creator is again inputting only that much of data into it, which could be attributed to the company who's got that chatbot created. So if that is the case, it would essentially be the company who owns that chatbot who would be held responsible at this moment, because that data is inputted because of them. But if there is a company that's doing this chatbot en masse, and it's just giving it to the person who essentially will incorporate it within their business, then it is the responsibility of that company to correct the chatbot. So where the question of products liability issues come in, and that is when you indicate it towards that law. But if it is supposed to be data inputted by that company, then of course you will look into consumer protection law, you will look at the contract law to see whether or not you can ascribe responsibility to the company that has put in that particular chatbot with the data that they have enabled. So, where this whole thing comes in is because at the moment, all these machines cannot be given a distinct legal personality, though there is an argument out there. But the fact remains it's being enabled by human. The data that is being inputted is also by human, and therefore there is a certain amount of control that is in our hand. But if it goes beyond that, where essentially human intervention starts getting reduced, that is when the distinction will arise that whether or not you need to give these kind of technology a very different domain and who essentially will be held responsible. But already there is an enablement. Like in Saudi Arabia, they're giving, there was a robot where they gave them a distinct personality and told them that, they're a citizen, and they gave them that citizenship, right? In Europe, there are instruments that have been enabled, saying that, there are constitutional rights enabled on those instruments, and they have a right to, speak up, and they have human rights enabled because of the data that has been inputted into them. So that shift is there. But I still feel it's going to be a long run journey before you reach there, where you say you need a different circumvention law.
We also have a question from one of the panelists, one of the attendees, and they're asking, what's the benchmark of this human intervention getting busy? I'm not too sure if we understand the right meaning of the question. I don't have the name of the attendee, but could we please have the question again? In the meantime, panelists, while the attendee sends us, a more qualified question with some more details in there. So, Savitha, I believe you're also doing some research on this aspect, and what has been your experience, and what are the kind of stats or analyses that you can share with us in this regard when we are talking of technology and law?
So, Ashima, what is interesting is if you look at the whole broad spectrum, whether you look at Europe, you look at USA, you look at India, Australia, everybody is enabled trying to understand what AI is all about. But the fact remains the perspective in each one of the jurisdiction essentially is different and is not the same plane, which is where the issue as far as any technological change and law is concerned gets hit. So what happens is that technologies such as AI, or even if it is any of your technology, it crosses borders, it crosses jurisdiction, and it's ubiquitous in its nature. But what happens is because of the globe, the restriction of laws and understanding stays within that particular jurisdiction, and that is where any person who essentially tries to circumvent the law is enabled, because of the fact we don't have a singular forum to address this, and we don't have the kind of, like in crime where you have your mutual assistance treaties and all in place. You don't have that kind of enablement in these kind of technology and the issues that are evolving. So the same thing is with the broad spectrum here. Like if you look at Europe, Europe's concentration has been mainly data protection laws. If you look at US has enabled a lot of discussion as far as AI and cybersecurity is concerned. But even there, each one of the states have enabled different aspect of law. They're looking at maybe IoT in one state. In another state, blockchain as a response is looked at. And in the third state, one is looking at, autonomous machines. And that's how sporadic the laws are. And it's the same, if you look at South Africa or you look at Australia, the laws that are evolving are more on policy issues. It's trying to look at how engraved artificial intelligence is, how important it is, and how to enable it. But none of the laws are addressing the regulatory circumstances that are required to address issues that are involved. And the reason I feel is because each one feels, because you've already done this journey with, your other technological changes that are there, the present setup of laws are more than sufficient. But by and large, one feels that when you look at such vast technological change that's coming in, the law might require a revisiting when you reach concepts such as strong AI, because then you're going to see very less human intervention as far as law is concerned.
Absolutely, Savitha. Thank you so much. Moving to Sanjay. Sanjay, do you agree we're operating in a narrow AI world, and would then it be right that tech and data are confined in borders, or are they borderless? What are some of the peculiar issues with respect to cross-border data and tech transfers?
Thanks, Ashima. With your permission, I would just, want to give a very different perspective of the whole IoT discussion, which my fellow speakers spoke about. Now, ultimately, M2M, machines are talking, everything is doing, but ultimately it is for who? It's for the consumer. It's ultimately for us. Now, if I am central to this whole subject, then today, if I look at it as a very, very simple lawyer who actually is today practicing, laws on torts, Indian consumer protection, contract law, what Savitha spoke, where do I go and, deal with these issues? And ultimately, there are 2-3 different sort of ecosystems what we need to look around. It's not like one size fits all. So irrespective of the technology, it's not, going to be what is good for IoT will be good for AI, and therefore, drones and whatever. Let's go to the basics. And the basics is the IT Act, what Sushanth spoke about. Now the question here is, if I'm talking about protection of sensitive personal data, which is what we are going to be discussing in terms of the law, the privacy law, ultimately the question which comes here is that if it is my sensitive data, which is picked up by the machine, and that machine then interprets and does its own talking to 2 different sort of sets of machines, where do I sort of see the liability parts of it? And when I speak about liability today, there could be an issue which arises that the device causes a body injury, a property damage, or a financial harm to the user of IoT. Then the question is whether the device has malfunctioned, who is responsible, which part and where does it go? And ultimately, as courts, we will have to go and see what is the evidence, what are the logs, where does it end, and who's responsible for it. So the question which ultimately comes is, whether the end user licensing agreements, which could be drafted by the IoT providing company to incorporate relevant clauses to these agreements, and to what extent, these events can be agreed or disagreed. And today, Sushanth spoke about third party. If there are third party, contractors involved in all of these technologies, then to what extent do I take care of it? The whole second theory is the privacy regulation. And let me address these, because to some part of it, I don't think we are addressing it. And what Savitha spoke about it, given especially from my perspective of being a trade lawyer, earlier we used to discuss goods, which is very, very clear, schematic. We all understand what's a box. We understand what's a product. Classifications are there. This is there. Today, it's impossible to understand what we will discuss, how we will discuss. And if the data has already started transgressing boundaries, then ultimately for me, the world is a super flat. Because, ultimately, I don't know where it started, where it ended, whether it left borders, whether it's sitting up on the cloud, and how are we going to sort of discuss these kinds of issues. So the complicated questions is of publicly available data for, training algorithms, how these traditional data categories, whether it is PI, SPDI, metadata, content data, how we will all revisit this in the light of AI, and how can a privacy regulation be applied to autonomous devices or decision making or surveillance gadgets and the laws around it. I think we need to sort of, completely look at it from all these angles. Last and not the least, every regulation today we bring in the country, the first sort of para is always the objects and reasons. And ultimately, that is where we will have to sort of start defining into it from three perspectives. One is the privacy policy should comprehend risks and formulate respective IoT or AI regulations to protect user privacy. Second, companies, must enlighten their customers with potential threats and educate them on the same, because ultimately even the consumer needs to sort of grow up and understand what am I using in my hand and how do it. And last and not the least is, if I am a provider, we should be pushed to introduce advanced security to understand all the security threats, and accordingly, whether it's a cyber threat, frauds, understand all those kinds of things. And last and not the least, it's the responsibility of the government and the judiciary to sit down together and solve these issues of the consumers. So that is where I would sort of leave it at that. Coming to your second question, which I will touch upon this whole AI. Today, the theory, what we all discuss as trade lawyers, especially when we are, sitting in small groups of countries discussing, not definitely leaving apart that as far as the domestic regulation is concerned, but the concepts over it. Now, what are the concepts? What are the principles? Today, we are talking about, explainable AI. Ultimately, we need an explainable AI. There is, of course, a theory of black boxes, which, clearly the black boxes today are technologies which are not designed to give reasons for their decision-making or decisions. Needless to, mention, there has to be a clear sort of trade-off between the performance of ML model and its ability to produce explainable and basically predictions which we can interpret. Today in the black box models, there are like models of deep learning ensembles. Today in the white box, there are linear and decision tree-based designs. Now, as a lawyer, as a judge, as a judiciary, we need to sort of break it down and understand all these, then definitely we need to go beyond these technologies, ultimately for the law to catch up. And for that law to catch up, it needs to sort of make it broad-based principles, interpretations, transparencies, and ultimately make something which makes the person ultimately responsible, ultimately transparent to interpret all this. So that is where I would leave it as far as the AI is concerned, because ultimately everything is going to be based on trust-based softwares and systems which we can all understand. Thank you.
Thanks, Sanjay. Yes.
Yeah, I just want to add here, so what Sanjay is saying is so true as far as the broad spectrum is concerned. And what is this whole quandary is very much, seen or addressed. If one were to see, like I'll give just two, aspects or two cases that were dealt. So in India, nothing as such on these lines have come forth. But in the US, because of the amount of robotic usage that is there, it has, already there are cases being filed. So one case was with respect to a robotic arm which was used during a particular surgery. Now, in that, the court essentially held the doctors responsible, saying that just because there was a malfunction in the robotic arm, it cannot be completely devoid of the doctor's responsibility, because they were essentially the arm that led the robot, and they should know and when to intervene, when not to intervene. On another very, very different case was again on a robotic ripper arm that essentially hit one of the owners on their head and he faced some grievous injury, and he went to court with regard to negligence and product liability and the inability to warn him about, that there could be a possibility of getting hurt. Now, interestingly, in that case, they said that, the defendants are allowed for a summary judgment and not the plaintiff, because the plaintiff was not able to ascribe responsibility onto the robot. So, that dichotomy of thought is very much prevalent right now in law. And it is all now subject to interpretation and the best case put forward and, the understanding that we might have as far as this. So it's going to be a long drawn journey before we reach somewhere. And, when our Information Technology Act came out, it's 2000, 21 years, we have not made any change. And the law keeps on evolving, keeps on changing, but we're still using that same circumspect law addressing this. And I don't see much of a change in the way it is dealt with, and probably that's the reason why people don't come forth and report cases or provide for issues, because they internally deal with it much more than rather having to go to a court that is interpreting a very archaic law still. So that's just something I just wanted to add to what Sanjay had.
Thanks for the interesting cases there. And, something that does come to mind, that what happens in a normal scenario, doctors are liable for negligence and, team heads are responsible, vicarious liability. What happens when you have a robotic arm in the mix? Great point there, Savitha. Inviting also thoughts from inviting thoughts from Mr. Abbas on this as well. Mr. Abbas, what are your thoughts? We also know that AI suffers from some sort of algorithmic biases and prejudices as well. It has been known to kind of not take kindly to certain ethnicities when on the roads or otherwise. Some of these examples have come out globally in the news. What are your thoughts on what we are dealing with here?
Just two quick points. One is on, let's say, the concept of personality of AI, and second is the decision making, which related to a question about the bias or the prejudices with respect to the data. Now, this is an area which is an evolving area, and there would be lots of divergent view because of the fact that it is an evolving area. There could be a scenario where a machine has been created by an individual. There could be a scenario where the machine has been created by an individual, but through a deep learning or a machine learning over the period of time, it has become a different machine than what it was created. So in a scenario where it is different and distinct from the one which was created by the creator, can it have its own personality? So that's a sort of an issue which I just want to flag, and I think possibly there is no definitive answer to this. On the question of the inherent bias or prejudices with respect to data, there are some case laws, and if not case laws, there are some steps which some companies have taken, but subsequently in case of a recruitment, I don't recall exactly the name, but in case of a recruitment, they had stopped using AI because there was an inherent bias with respect to women, because artificial intelligence essentially is driven by data. So data has to be very pure and unbiased to get a good output. Sanjay had talked about this concept of a black box, and I think that's very important in artificial intelligence, because if the decisions are taken by machines and machines are run by algorithm, what goes into algorithm is very important. Let's take a hypothetical decision that the government is taking decision based on the machines. Now the decision, which is an outcome of some input, has to test the principles which are enunciated in the fundamental rights. For instance, government decision needs to be non-discriminatory. It should satisfy the test of reasonableness, the test of equality. So I think when it comes to an AI, at the algorithm level, it has to be ensured that it's not only a design by, let's say, ethics by design, but those constitutional principles need to be built in the algorithm itself to ensure that those decisions, as Sanjay say, can be explained those decisions should be transparent and the outcome should satisfy the constitutionality, the principles enshrined in the constitution, let's say. And I think to my mind, Niti Aayog is doing a good work in respect of this. And it has enunciated 7 principles in a responsible AI, which talks of principle of equality, principle of inclusivity and non-discrimination and others. My last point is with respect to Savitha's reference to an IT Act, which was enacted in 2000, and it's 21 years, and it has become an outdated. But while she has a point, but I'll give you another example, that we have an Indian Telegraph Act enacted in 1885, 135 years old. And under that act, we are talking about IoT, Internet revolution, all the liberalization in the telecom sector, all digital revolution which is happening under an act which was enacted 135 years ago, when these services one couldn't have imagined. And all because of a very good definition of the term telegraph there, which includes all the services which exist today. In fact, one aspect of that definition is that even if there is some service in the future where communication is through visual, it uses the word visual in that definition, that will also be included. So we need a good drafting as far as the laws are concerned, a sort of a forward-looking drafting where the people who are drafting could predict what could be the possible scenarios in future. Thank you.
Thank you, Mr.
Ashima,
Abbas.
I would like to add something to it.
Sure. What a fine example from Mr. Abbas. And Sushanth, over to you for your input, please.
3 very interesting things that I would like to very short.
Sushanth, could I please have you closer to your mic, please? I think.
Yeah, now I'm audible better?
Yes. Thank you so much.
I just want to make 4 points. So I'll make it very short and concise. Now, the first thing, that comes to my mind is that, already we started to see autonomous vehicles even in India. See, we have this vehicle called MG Gloucester, which claims itself to be the level 1 autonomous vehicle in India. So when I just out of curiosity walked into the showroom and then tried to understand because of my fancy towards internet and autonomous vehicles, I asked him these 3 fundamental questions. Number 1, is the insurance provided here covering cyber crimes arising out of the vehicle? Because it claims to be an internet-enabled vehicle. Number 2, to what extent is it compliant with the existing laws of the land because it is collecting my sensitive personal data and information? Number 3, in case there is an external cyber attack, let's say somebody hacks into my system and then meddles and then tries to alter some settings over there, what could be the kind of remedy as a user of this vehicle? Till today, it's been more than 1.5 years and I have not got any piece of answer from them. I think these are very, very interesting questions that can come across when we talk about autonomous vehicles, because the fundamental aspect is that what happens as a user, how do I redress my issues pertaining to this? Because we are simple people, we don't understand complicated stuff, but we intend to go for smart gadgets and we have an intention whether this kind of gadgets can make our lives more easy than making it more complicated. So this is the first thing that I was wanting to put across. Second thing is that when we spoke about the algorithm bias, I think a very interesting case came to my mind, which is called the Wisconsin versus Loomis case in 2016, wherein an algorithm called Compass was used for the purpose of evaluating the likelihood of the defendant committing more crimes. I think that algorithm generated a high-risk report, and the judgment was based upon this particular algorithm. And the Wisconsin Supreme Court rejected the appeal of the plaintiff and of the defendant, and then it relied upon the output of this algorithm. And it had made a very interesting point over there, saying that the output of the algorithm is sufficient to indicate the level of transparency. I think that's another very interesting point that came to my mind. And the last point that I would like to make over here is that, we have been talking about smart contracts. Blockchain is something that is making use of these smart contracts. But what happens in case of the enforceability of smart contracts. Okay, we have a challenge in India. I don't want to get into the technicalities, but only one question. In case there is some unincidental, or what do you say, something that had happened out of ignorance. I don't even say ignorance, something that has happened unintentionally. There's a unintentional code of error that has actually changed the entire terms and conditions of these particular smart contract. Then what happens to the legality of this? And how can you repudiate, or how can I, frustrate the contract being signed specifically using these smart gadgets, whether it's AI-based contracts or whether it's smart contracts? I think these are some questions that are very, very common, because I sign it, I will want to understand whether, is it a human being signing it, or on whose behalf is it going to sign, in case I want to change, because all these are ultimately going to making use of technology and algorithms and coding. So in case there is some unintentional code, what happens thereof? I think these are the three things that, I would like to put across before I complete. And one last point, what I would want to make here is, I think, webinars like this should be the provoking thoughts, and then, they must act as a catalyst for building up the legislation, because there are lots of think tank organizations, research organizations, not to name any, because what I believe is practical aspect should be also dealt with apart from theory, because merely putting theory into the research activities lands us nowhere. And I think research organizations and AI specifically and blockchain and these technologies will have to realize that it's not just mere theory, but practical experience would have to be put in. So
Absolutely, so thank you so much for that thought. And although we're a little over one, I will take this another few minutes if our panelists don't mind to extend this conversation. Sanjay, coming to you, I understand from our conversations before that you had some sort of an experience with blockchain smart contracts. And, it would be really great if we could hear your experience on that, and it would kind of also go with Sushanth's concerns there. How was the experience, and did you find any bumps on the road?
Yeah, no, thank you for that question, Ashima. When actually Sushanth was talking about any untoward incident where intentionally, non-intentionally, and these sort of legal words which we say men's, this thing. The question when we were doing this, and my role was pretty much very, very limited to trade facilitation and customs, processes. The important part there was from a documentation perspective, various agencies who are talking to each other, and the whole GVC, which we talk about the value chain, starting from sourcing, booking the order, right up to facilitation, customs, banking documentations, and ultimately setting logistics and off to the ultimate buyer. You'll have to sort of look at various different roles, what they are being played and how exactly there are errors. There were three sort of terms which I now remember: explainability, traceability, and scrutability. These were the three terms which we all sat down to benchmark each of the processes in question to sort of answer some of these things which become very important for us to see whose fault it was. Because ultimately, what Sushanth spoke about, the concept of mens rea, whether it was intentional, I was important, it was the machine's fault, it was somebody's fault. And that, has to sort of play some role. The other interesting thing, what is also being discussed right now, is whether there should be an algorithm regulation before we sort of discuss how exactly, it's going to be sort of used. And one of the things which are being discussed on a global deliberation is whether questions on whether AI should be left to be autonomous, should always have a human in the loop, and last but not the least, should it have a kill switch when used in context also to be answered, some of these. So ultimately, you are not going to be sort of leaving it only for the machines to sort of start talking and all this. There has to be a secondary benchmark. There has to be a secondary check to these processes and ultimately sort of take it from there. So whether it's blockchain, whether it's AI, whether it's IoT, ultimately everything is there, but you will need some sort of a second check based on evidence, transparency, which helps the law to find answers and take it to its logical extension out there. Thank you.
Thank you, Sanjay. Thank you so much. And thank you so much, panelists. We could have, one word each from you as your closing remarks. Savitha, over to you. What would be your one key suggestion to either the policymakers, lawmakers, or, any word that you'd like to share with us today?
Thank you, Ashima. So I think Sushanth had very brilliantly put it there, so this is just not about a theoretical understanding of what perspectives are as far as technology change and law is concerned. But, one has to look at, what are the practical ramifications are there. But the fact remains also is whatever we do, the law will never keep pace with the technological change that is going to take place. So therefore, the law that you essentially give is maybe what, Mr. Abbas said, that you have a Telegraph Act, which has over the years still stood the test of time to somehow get interpreted in, any question or circumstance that essentially arises. So therefore, what we probably need is that any new law that is coming in should have that kind of a propensity to be able to be ever evolving, because it's very difficult for the law to keep pace with the changing times. But you do require a law that understands that it is a changing time. And that kind of a law that would evolve would be best addressed if one has, both the practical as well as, the legal theories balanced out completely.
Thank you, Savitha. Mr. Abbas, over to you. In a legal system like ours, would a flexible law or a visionary law like the Telecom Act, what are we looking at to resolve the issues that keep cropping up?
Technology normally is ahead of law. I think we should acknowledge that. And at times there is a clash between law and technology. Law, to my mind, should not tame technology. It should regulate and enable technology with adequate safeguards. If probably that is an object. And also, I think there should not be much gap between technology and law, that we let technology grow it wants without any regulation. So policy intervention, proper regulatory framework which enables technology with adequate safeguard, especially with so many emerging technologies in India, is the key here.
Thank you, Mr. Abbas. Sanjay, are we looking at regulations tying down technology, or is it likely to actually give it more wings and make it more borderless?
The term which I would like to sort of use in this context is cross-fertilization of laws now. Basically, not only look at domestic regulations, but ultimately you will have to look at international regulations and assimilate in such a way. And I agree with Savitha, it has to be dynamic. You sort of cannot put it in a box and say, this is an 1881 and that's it now. You will have to now move very quickly. You will have to move forward. And ultimately, given the constitution where we are coming from and the economies in which we want to sort of live in, you'll have to sort of show that the justice, of course, needs to be done, but justice needs to be seen to be done. And therefore, you will need regulations which are borderless and clearly which sort of sticks to our constitution and where we are. Thank you.
Thank you, Sanjay. Thank you so much. Sushanth, over to you for your inputs and closing comments.
Yeah, thank you so much. I think it's been a very, very interesting deliberation. I think once again, we had a lot of new pointers. I think all the panelists were giving up their own viewpoints. I think it's a very interesting deliberation. And to add to it, I think, I totally agree with the fact that, we cannot have one law for the lifetime. I think what really is important is we have the Information Technology Act, and it's technology neutral law. One of the key recommendations that have come up in the 2008 amendment is that we have made the entire law as technology neutral. We have added something called a second schedule, wherein we have the freedom of just incorporating the change by placing it in the second schedule and not going through the entire cumbersome process of coming up with the new legislation. I think such options should be provided so that the new changes can be done effectively. And it's a very simple process of just putting the same in the second schedule and then rolling it out in the official gazette. I think when we have such a very, very simple option, I think it's very important that we utilize the same and then adopt the same even for the new laws to come. I think this is the only thing that I can see on the horizon.
Thank you, Sushanth. Thank you so much, experts. Thank you so much for those lovely, not only bringing out and shining light on the issues, but also along the way sharing your own solutions and practical solutions with us on the on those areas. So thank you so much for joining us today. It has been a lovely conversation, and it's been so wonderful to have you with us. Thank you so much once again for your time.
Thank you very much.
Thank you so much.
Thank you so much.